So, dear friends and colleagues, it's a pleasure to welcome you to tonight's second edition of the ICTY Legacy Dialogue series, this time with a focus on the defense. So, judging by the numbers, it seems that defense work has actually been pretty popular, and that the story of the defense is actually one that people are eager to be told. We have, I think, tonight some of the stars of the defense world here with us. I think a real dream team. Mary O'Leary, Colin Rohan, Chris Gosnell, Gregor G. Smith, and Dragan Ivetovic. The defense perspective is often sidelined in debates on international criminal justice. In most international criminal courts and tribunals, as you know, the defense is actually not formally an organ of the court, but it's critically to the justice process. The disparity between the accused and the accusers has been one of the structural weaknesses of international criminal justice. American Chief Prosecutor Robert Jackson stressed the importance of fairness at Nuremberg. He said, "To pass these defendants a poisoned chalice is to put our own lips as well." Formally, defendants are presumed to be innocent, but some claim that defendants might sometimes face maybe a little bit more a presumption of guilt than a presumption of innocence. A fair and an effective defense serves obviously not only the defendant, but the international criminal justice system as a whole. It protects the equality of arms between the prosecution and the defense and the rights of the defendant to a fair trial. It's also essential for the integrity of the judicial process and the process of truth-finding. Defense counsel are not only partisan agents, but to some extent officers of the court. The story of the defense at the ICTY is, I think, in many ways pioneering. Defense counsel have set some of the institutional footprints. For instance, with the creation of the Association of Defense Counsel, which was then crucial for the adoption of the Code of Professional Conduct for counsel. In the courtroom, many of the lawyers fought some of the original battles that highlighted weaknesses in the existing system. For instance, in relation to the equality of arms, the defense comes in quite late, when a case hypothesis has been formed by the prosecution and evidence has been collected. It's been a struggle to carry out sometimes in independent defense investigations, and defense lawyers often face struggles when they go on the ground. A second challenge is, of course, the large amount of material that the defense is exposed to. So the defense often has to shoot at a moving target that makes it difficult to prepare an effective defense. In the early history of the tribunal, the defense often faced huge indictments based on very broad liability theories, such as joint criminal enterprise or command responsibility. The rules were quite often changed. Finally, the fate of defendants after acquittal or post-conviction often remains a challenge. So these are just, I think, a few of the issues that are part of a broader story that needs to be told. And we have here some of the main protagonists. I want to mention that Colin Rohan has just published a book on defense perspectives on international criminal justice with COP, which I would warmly recommend to you. But first, I would like to give the floor to Mary O'Leary, the Vice President of the Association of Defense Counsel, who will moderate the panel. Thank you so much. A warm welcome, Marie.
Thank you, Carsten. Yes, I've been tasked with moderating this panel who has so much experience and enthusiasm. It will be a difficult task, so bear with, I think. But I want to welcome you to what we've called Experiences from the Front Lines Defending Justice. We were asked to put together a panel that would give some behind the scenes, give some insights into what defense work was actually like and how it developed in the time at the ICTY. First off, before I forget, and I might later, I want to make sure that we thank all of the people involved, the ICTY Legacy Dialogues, for inviting us to have this defense panel and discuss this here. Leiden University and Grotius for hosting, EU for support. I also want to thank ADC for organizing, and my panel for coming today to share their experiences. And of course, all of you. The participation is fantastic to see that there are people interested in this. My experience, I only came to the front lines of defending justice here in 2006, so it's a little bit late to the game in some of these stories because there was a lot going on before that time. And when I arrived, the completion strategy was well underway. We were already closing. It's been closing since the minute I arrived. But now we're actually here and we're looking back. And the era has changed entirely since 2006. There's a lot of familiar faces in the room who have worked here as long and on these cases and have that experience too in how things have changed, shift, the activity levels, the number of people who are actually around to participate have all changed. Right now we have one team who's awaiting a trial judgment, 6 teams awaiting an appeal judgment, and that's really all for defense at the ICTY specifically, which is quite different from when we had 26 teams, all working in the same space at the same time. Trial teams, that's not even counting the appeals teams, the pretrial teams, and everything else going on. But I was thinking about the topic here and the legacy and going back to this, and recalled that in 2013, the defense themselves, the ADC, organized a legacy conference. And it was a fantastic event. So I actually went back, and you can find the whole transcript with introductions and all of it online at the ADC website. And I would encourage you to go read it, because I reread it for the purposes of today's panel, and it's fascinating. A lot of the people who are on the panel today contributed, and so many more. And I wanted to focus a little bit on some of the things that are in there, because we have fantastic voices here, but there's so many different experiences that came before the tribunal. Working on a defense case has so many variable factors that it really is a different experience in each case, not even just for each attorney, but in each specific case they have, and given the time and many other factors. And in going through it, the introduction, there is a passage written by Judge Alphonse Ori. And he had gone through and actually reviewed the legacy conferences that had happened between 2010, 2011, 2012. And he was a bit dismayed in his writing that no defense participants had been called, people who had actually appeared before the court representing accused at the ICTY were not at those to present their experience in those years. And he actually noted then in his passage, and I'm quoting here, "Where the defense in previous legacy conferences may not have been offered an adequate role to play, it has been shown its inherent fighting spirit and convincingly taken revenge with its own conference and this publication," which is kind of true. And that's kind of what Carsten Stan was speaking about in the pioneering spirit, only it's a nicer way of saying it, maybe. But the ADC and the Defense Council have collectively taken revenge in many ways to make sure that their rights are asserted, to make sure that the presence is heard, and the voice of the defense appears at all levels as an equal party to the proceedings with the prosecution. Going through the foreword of it, which is actually written by Colleen Rohan, she noted that this conference that we had for the defense was the first of its kind, in the sense it was the first time we were talking about the defense's view about these tribunals, these courts, and what had come before for lessons learned. She was very pleased in this by the hundreds of participants. Just as we're pleased today to see all of you out in the audience, it was amazing to see the crowd that was actually there at that time. And she said, and I will quote her, with her sitting next to me, which is a horrible thing to do, but I told her I would do this. "One imagines that in 2002, no one in the fledgling ADC-ICTY envisioned a conference of this type ever taking place, much less attracting the attention and energy of such a diverse group of people." And it was an important event. The president at the time, Novak Lukic, managed to represent on behalf of the 220 counsel, they had done some math here, who had appeared before the court, hundreds, over 600 support staff who had worked on defense teams. The numbers are astounding of the people who are out there. I can't even, if I had hands right now, many of you have worked on defense cases at the ICTY in some capacity at some point in your life. The 200 investigators, 100 experts. And a lot of the stories go back to equality of arms, as was also just mentioned now. A lot of these things come into play as to how equality of arms can be better achieved in the future when we're looking back at the lessons learned. We had some exchanges between some of the counsel who had practiced there. One exchange was actually one of the people in the crowd who was a former counsel, the late Cynthia Sinatra. who wanted to ask the panelist, Mira Topuskovich, who was also a counsel, do you remember, she said, Mira, do you remember when we arrived at the tribunal? And I'm quoting from the transcript here. As far as equality of arms goes, the defense room had no telephone, no copy machine, no computers, nothing at all in which we could compete with the prosecution. To which Mira Topuskovich, also a counsel at the same time on the panel, said, yes, Cynthia, I do remember that time that we opened the gate of this tribunal, and it was a very hard time. And it continues on the discussions that they have about equality of arms, and even goes back further where we have Stephen Kay, Queen's Counsel, giving a story about how he and Judge Ori, who were working in pretrial stage of Tottage, that's how far back we're going now, and they had an idea that they might go to the library. He tells this story, and much better than I'll ever tell this story. And on paper, it even tells it better than I'll do it. But he talks about going to the library to find resources for their legal submissions, and they found one book. And it was Archbold's Criminal Pleadings from 1968. He said, sitting proudly on the shelf, he said. And he said at that moment they knew they had to band together and find a network of people and a network of support to do the job that they'd been tasked to do. And what he did, he said, is they went on to write a letter. And I'm going to read this quote. For anyone who's young in the room, prepare, you may be horrified by this. The quote was, "It was a letter then, as none of us had email addresses. I do not think there was even an internet. Or perhaps that just started in 1996. So we're talking about a span of time where we weren't just developing law, procedures, substantive, developing in technology, developing in resources that we didn't have in 1996, that now it's a given that you're going to have an email set up, probably 10. Something right there that the developments have changed. But the legacy that comes from this, you have then reflected in some of the comments of people, counsel who are working from the former Yugoslavia. Adina Razidovic, in particular, said that one of the most important things is that she wanted to take that legacy with her and share it with her colleagues in Bosnia and Herzegovina. And that way, they could fight for substantial law, procedural law, and the rights of the accused there, in the courts there, which we'll hear about some today. And some people were just a little bit more succinct. For example, Richard Harvey just summarized, defense rocks. Also a lesson learned. But that was 4 years ago now, and now 2013 to 2017, we have even more wisdom about the development in the final years of the ICTY. And we're going to hear about that now and change perspectives, perhaps the same perspectives from some of the panelists here, as to what we need to do to go on into the future. But what I do want to do is read one more quote, because it's my favorite one out of the whole thing, and it's a little bit longer, but I think it's pretty vital, because it discusses the importance of the defense function. And it was given by Judge Moloto. And he said, the main important function that defense counsel must think of at all times is a very obvious one: defend your client. And defend your client to the best of your ability. Refuse to be browbeaten by anybody in the exercise of this duty to your client. Whether that person is from the prosecution, whether that person is a judge, whether that person is another counsel. Your job to defend your client, and if at the end of the trial, whatever the outcome is, you can say, I could not do any better, then you are entitled to a peaceful sleep. And I find that quote so profound as far as the role that's played of the defense counsel before the courts, and so succinct that I've actually printed it out, put it up on the wall. And I think right now what I want to do is introduce the panel here, who every single one of these people is entitled to a peaceful sleep, because I've seen all of them work constantly, tirelessly, and the best they can for every one of their clients. So let me just introduce them, though I think they don't even need introduction, especially to a lot of the people in the room, some of them who've even worked with them before. I have notes on their biographies. It's not that I don't know who they are, I forget, because they've done so many things, and they're so all over in the field of international criminal law, and I don't want to miss anything. Our first speaker, though, I'll announce them all at once. Our first speaker is Colleen Rohan, Miss Colleen Rohan, who is working in the ULEX courts currently. She has worked at the ICTY on several cases, I believe, beginning in Limai, Haradinaj, Popovic et al. was one of the first cases, I believe. Karadzic is standby counsel. and the Perisic case. She is an ADC past president, and she has contributed greatly to the mother of this manual on international criminal defense, which she will discuss when she discusses the ADC. She is a founding member of the ICLB, a member of 9 Bedford Row, and many, many, many other things. Our second speaker will be Mr. Dragan Ivetic. He has been at the ICTY on cases since approximately 2001, I believe. That's what your bio says. He's most currently working as a counsel on the Mladic case and as a legal consultant on the Chorich case, which are both awaiting judgment in the coming month. He has also worked on the Milan Lukic case, on the Sreten Lukic case in Milutinovic, and on an earlier case that was referred back to BIH via 11 bis, and discussed some of that. He's a current Association of Defense Counsel Vice President, and he has had, as I had said, experience in BIH State Court. Our third speaker, I think if this has been negotiated properly, will be Mr. Christopher Gosnell. He is currently appearing at the ICC on 2 cases, Mr. Bosco Ntaganda and in representing Mr. Magenda in another case. He's also been at the ICTY on several cases. He was in Hadzic case, representing also Mr. Borovchinin and Popovic et al. He's a current ADC vice president. He's been defense counsel at the ICTR and at the SCSL. He also has experience at the ICTY in the Office of the Prosecutor and in chambers at the ICTR. Also in victims, I don't want to leave that part out, in the ICC and the STL. And last but definitely not least will be Mr. Gregor Guy-Smith, who is also presently representing persons before the ULEX courts in Kosovo. He's worked on multiple ICTY cases as well, in Limai, Haradinaj, Perisic. He is an ADC past president. He is also a founding member of the ICLB and a member of 9 Bedford Row. And I haven't included, because it applies to all of them, they have lectured continuously about this topic and all topics important to defense counsel, and have served on numerous committees of the Association of Defense Counsel, the ADC, as will be colloquially referred to throughout the discussions. So without further discussion from me, I'm just going to let Ms. Rohan have the floor.
Begin with the ADC. Hello, everybody, and it is really nice to see so many people coming out at 5 o'clock on whatever day this is. I lose track sometimes. But welcome, and I hope that we give you information and entertain you, and we're definitely going to ask you to join in with the discussion with us, ask questions, and we hope to get a nice discussion going. I have been given the lovely task of talking about the ADC, and I say lovely because it's an organization that internationally, in terms of defense attorneys, I think is unique. It's a pioneering organization and extremely successful, given how it started, where it started, and how international law and the courts have developed since that time. The ICTY, when it first opened, I think Karsten was describing things rather kindly when he said the lack of provision for the defense was a structural weakness. I think it was more of a disaster. No one had thought anything through about the role of the defense, including in the building. For example, the defense had a tiny room. There was a coffee machine there. Defense counsel couldn't use the library, which I've always found to be kind of an oddity, couldn't eat in the cafeteria. And then to this day, defense counsel is issued with an identification card that you go in and out of the tribunal wearing that has red on it. And in the earlier years, there were signs in the tribunal that said, people with red passes are not permitted here, including the Office of Legal Aid and Defense, which is theoretically the one office there that was available for defense counsel, was off limits. We would have to call in and to get through the door. Now, the people who worked in the office are lovely people, and you had good relationships with them, but it was a little daunting and off-putting psychologically to, well, when I came into the building for the first time, which was 2004, I think, to see these signs. It wasn't exactly a welcoming, warm, and fuzzy atmosphere. The problem with that isn't just a social one. There were other issues that really directly impacted on the defense ability to do a case. For example, there was email, but we would receive huge amounts of disclosure from the prosecution, and there was no way to get access to it unless you were physically sitting in the building of the tribunal if you were a defense lawyer. And of course, there's no defense office there. So initially what happened is that people would go to The Hague pre-trial, and pre-trials can last for 2 or 3 years, to read the disclosure, but the resources were such that you were only permitted to go a couple of days out of the month, or 4 days out of the month, I forget how much it was. So it effectively precluded the defense from reading the information in their case. When Gregor, who we'll talk later this afternoon, was elected president of the ADC, he did a spectacular thing, which is he negotiated with the ICTY to give counsel a remote key, a thumb drive basically, but a remote key so that you could be home wherever it was you lived, stick that key in a computer, and you could read disclosure from wherever it was that you were located in the world. And of course, defense counsel come from all over the world. They don't live in The Hague until the time of the trial in most cases. But when I think about that in retrospect, and I wonder how it was that we even handled that. It was definitely the kind of issue that led to the development of the ADC. And what happened there, this is off, what happened there is the lawyers who were at the tribunal in the early years realized that every time there was a case, the teams would go in and have to negotiate independently, one separately, with the OLAD to negotiate resources for their case. So one person might think of one thing to ask for and one another, and it was quite chaotic from the defense perspective about how the defense could have entree into this institution where they needed assistance, but there was no organized structure for their existence. And in fact, they were excluded from significant portions of it. So the defense lawyers began to talk about maybe we need to develop an association. The judges who were at the tribunal at the time felt this was a good idea. And their view of it was an association of defense counsel will also help in the self-discipline of whoever the people who are in the bar at the time, and that would be a good thing to have some form of disciplinary mechanism that was self-enforcing for defense counsel. So there was a nice melding of attitude at the time. The registry assisted in creating a constitution for this group. And what happened was that over that period of time and throughout that negotiation, ultimately a constitution was written, a rule change was made to the rules that said if you want to have a case at the ICTY, you must join the ADC as defense counsel, obviously. You must be a member of the ADC. Requirements for your experience, background, that kind of thing were written into the statute. The ADC, as it organized, assisted in screening applicants, so we started to participate in bringing our own members in, and there it was, ta-da, the organization was born. I think at the time, really, the idea was that it would have kind of a limited role in that it was the self-disciplinary aspect and other sort of organizational aspects with dealing with the registry. But what happened, and this is why I love this organization, is that its members came to see the potential for being organized as a group who are not, at the time certainly, and I'm sure it's still true, exactly the most popular with the media, in part because, and the public, in part because people don't understand what it is that we do. They don't understand the defense function or its importance. Your clients are usually referred to as monsters or something calm and intellectual like that in the media. And so it's a difficult role to play. And the council in the group, and with the structure of the Constitution, started to do various things. For example, there was a disciplinary committee, but that committee wasn't there just to tell lawyers that they had somehow broken the rules. They were there to assist them with ethical problems that came up in cases, dilemmas that lawyers didn't necessarily know how to handle. And so that committee could issue what was called an advisory opinion that was confidential, And if you had a problem, you could go to that committee and get real solid practical assistance that I know from my experience at being on that committee and others here as well, really helped to avoid problems and get lawyers through difficult issues with their clients or with the court that maybe otherwise would have created a problem. Now, over the years, the tribunal has developed some trust in the ADC, and members of the ADC sit also on the disciplinary panel of the tribunal itself and the disciplinary appeals board. So the members, the ADC has really been brought into the structure of the tribunal in that sense. We also organize a training committee, and in the early years of the tribunal, this very, very important function, because people are coming in from different legal systems, and no matter what system you come from, you walk into the tribunal where it's not a system that's your system. It's a mix of common and civil law, it's whatever happened yesterday, it depends on who the judge is, it's not what you're used to. So the ADC created a training committee and made it a priority to train lawyers who came to the tribunal about how that system worked there. So, for example, people from the region of the former Yugoslavia didn't necessarily have skills with cross-examining witnesses because that wasn't something they did within their own legal system as it was done at the ICTY. And years back, there was actually a full-on weekend training held for anyone there who had a case, so it was all lawyers coming in, to conduct direct and cross-examinations. It was a really, really useful weekend, and this was 2005 or 2006 when this happened. And that training has carried forward. Now, the people who work on teams there, for example, not just the lawyers, but people, non-lawyers working on teams, have access to training from the ADC on all kinds of things, writing skills, argumentation, ethics, which was a huge one, that people who were not lawyers would have to learn the ethical obligations at the ICTY. And again, the idea being, these are our people, these are our members, we want to make sure they're well trained, but we also want to make sure that they're effective in their jobs and they're not going to run across a problem. And this leads me to the lovely story of the manual, which is my baby, and I admit this. And it's a story of revenge. To put it mildly, that revenge tastes best served cold. It's really true. The ICTY decided years back, that they were going to put together, as part of their outreach, a manual about the best practices at the ICTY. And in the process of doing that, contacted OLAD, I think it was. I was contacted through OLAD. And they asked the defense write a chapter for this because they wanted to have that perspective in this manual. I have no idea how many people they asked, but I ended up having this task, and I sat down and I wrote this chapter, and I was told, don't be too critical, don't get into kind of a defense frenzy and hysteria, just say what's happening. So I did that, and I was very polite, and I was very diplomatic, and I sent it in, and then about 2 months later, I got an email saying, the prosecution doesn't appreciate the fact that you talked about problems with disclosure at the ICTY. They wanted that edited out, so rather than editing your chapter, we're just not going to put it in at all. So the manual went out with no comment from the defense. The group that was assisting in funding this manual, which was through the War Crimes Justice Project, was a group called UNICRI. Some of you may have heard of them. And I had been going to Sarajevo and meeting with UNICRI because of this, the manual that was coming through the ICTY itself. So UNICRI called me and they said, wow, we think this is kind of not such a great thing that the defense will be excluded. So if we just had you write your own entire manual, would that be okay? And of course it was. So a bunch of lawyers got together and we created the manual on best practices, which as far as I know is the only, and people will immediately tell me I'm wrong, I'm sure, but it's the only manual that has been written by lawyers who actually do cases in court and have done all of these things and have the experience. And it was put together specifically to train people, not just at the ICTY, but also in the region of the former Yugoslavia. Now, what's happened since, of course, the manual is available in English, but it was translated into BCS, then into Albanian. And I found out a couple of years back it's circulating in Africa, although I've been trying to get money to translate it into French. I haven't gotten the money for the French yet, but Unicre translated it into Spanish. So it's moved around the world, and although it's a minor, kind of a small, humble book here, it's played an interesting role, and you can thank the ADC for that and all the lawyers who participated in creating this manual. I don't want to run over my time. I'm okay? The other thing we've done is started mock trials. So we give, you know what a mock trial is, I don't have to describe it to you. The ADC started to put on mock trials 6 years ago, I think. It was quite a while ago. And that had never been done at the ICTY. And there again, there was institutional support for this that wouldn't have existed in the early days of the tribunal. By that point, the ADC having established itself and having a reputation for being a reasonable group of hardworking people for the most part, we went and asked the tribunal, can we use the courtroom? Is that all right? And we thought that we would have some of the lawyers from the ADC sit as judges and try to make the thing very, very realistic for the people who participated. What happened was that the ICTY came back and they said, well, you can use the courtroom. We're going to have real judges come in, though. Is that all right? The judges want to participate in this. So the judges, several people who are judges at the ICTY, became very enthusiastic about this and participated, and it's been going strong ever since to rave reviews, to be very modest about the whole thing. And we now have people coming in. It was originally for people, again, who worked within the ICTY, be they defense, prosecution, registry, chambers, it didn't matter if you could participate in this. Now we are starting to get some people from the outside who want to come in and participate. So that's been a really, I have 2 minutes. That's been a really positive development, I think. There are 1,000 things the ADC does. I have 2 minutes, so I can't go through all of them. I told you I would be enthusiastic about this because I love this organization. I'll just make a couple of final comments. I think it's really important that people who defend people in the international criminal tribunals know each other, get together, talk, are organized so that we can support each other in what's a very, very difficult job. Prosecutors have offices where this support exists in one way or another, theoretically, and well, they should. I'm not being critical of that. But for the defense, it's more difficult. You really do need to have an organization, and an organization that starts to stand up for the people in the defense community and be there for them, providing training, assistance, whatever it is that it may be. And something that just came up recently with the ADC, which to me really, really shows how well this organization has established itself over the years, is that there was an issue about an ethical code that's being drafted by another group, and the details of that don't matter. But the ADC came out as the oldest defense organization that actually deals with cases involving prosecutions or hearings of lawyers for ethical issues, reviewed the code, found it wanting, and put out an open letter to the community who will be looking at this issue, which is very powerful and very honest and really reflects, I think, the role that the ADC has come to play, which is to provide some guidance in the community so that people think about what they're doing and can be as effective as they can. So I have a lot more to say, but it's someone else's turn, and thank you for your time.
Thank you very much, Colleen. And just in case you didn't know, there's a healthy amount of time for questions at the end, so there'll be more opportunity to discuss the ADC if you have any questions, or if Colleen just wants to freestyle a bit more. But right now we're going to move on to Mr. Dragan Ivičić to give us some comments as well about his experiences.
Good afternoon to everyone. Today my task will be to discuss with you briefly, the emphasis on briefly since we're under time limits, the legacy of the ICTY from the defense perspective as it relates to the domestic courts in the region of the former Yugoslavia. Now, while my biography as an ICTY lawyer is perhaps more lengthy and better known, I assure you that my role here today is not just to talk theory and to give you hearsay from colleagues who practice in the region. Indeed, I am one of several foreign attorneys licensed and who have practiced before the State Court of Bosnia-Herzegovina in relation to war crimes cases. To understand how I, as an American attorney, ended up in Sarajevo, we must start our journey by briefly looking at a specific rule within the ICTY rules, Rule 11 bis, or 11 Bs. It was originally adopted in November of 1997, amended multiple times, most recently in February of 2005. The initial version was rather restrictive on how cases could be referred back to national courts once they had been sent to the ICTY. But with the amendments, the rule became less restrictive in its application. Therefore, using this rule, indictments and indeed accused and detained persons from the ICTY who often had spent significant time at The Hague, at the ICTY, awaiting trial, were sought to be transferred to various domestic national courts in the region. I think in grand total, there were 6 cases involving 10 accused referred back to the State Court of Bosnia-Herzegovina, 1 case involving 2 accused referred to Croatia, and 1 case with 1 accused referred to Serbia, and several other motions were either denied or withdrawn. Now, in line with these referrals, the ICTY's Office of the Prosecutor and the OSCE in Bosnia-Herzegovina created a mission to monitor the cases that were transferred there. And that mission lasted for 5 years, from 2005 until 2010. Depending on the state involved, the regional justice system created various new courts to deal with not just Rule 11 bis cases, but also war crimes cases that were being tried domestically, including so-called rules of the road cases, which were essentially ICTY prosecution investigations which were turned over to the courts in the regions once the ICTY mandate to issue new indictments ceased to exist. So, in the 3 countries wherein ICTY detainees were transferred via Rule 11 Bs, we had 3 different approaches. The Court of Bosnia and Herzegovina was imposed by a decision in 2002 by the High Representative and adopted by its parliament in July of that same year. It became operational in January 2003. So this was a separate new court. In terms of Croatia, in October 2003, the parliament passed a law that, among other things, created 4 new courts within the existing county courts of Zagreb, Osijek, Rijeka, and Split to deal with war crimes cases. And in Serbia, in July 2003, the Serbian Assembly established a war crimes chamber within the Belgrade District Court and a war crime prosecutor's office to, again, deal with cases relating to war crimes, but within the existing judicial structure. But in each case, these new courts or chambers often adopted procedures or rules similar to those found at the ICTY or in common law jurisdictions, and inherited evidence files from the ICTY, which were at times different or even at odds with the pre-existing domestic system, which had been a continental-based civil code system. And all 3 of these state courts operated differently. For instance, the State Court of Bosnia-Herzegovina at the beginning had a 3-judge panel whereby 1 judge was a local and 2 were internationals. And there were also international prosecutors working alongside local prosecution attorneys. Often, these were common law practitioners rather than continental law practitioners. Naturally, that meant there was a learning curve and some difficulties on the defense side to adapt to and practice within these new courts, especially for those that did not have prior experience with these common law concepts or with ICTY or other international law experience. Thus, it was under this sort of backdrop that I came to serve as lead defense counsel in the so-called Mejakic and others case before the State Court of Bosnia and Herzegovina for approximately 2 to 3 years, concurrently with my representation of another client before the ICTY, during the time period of 2006 through 2008. That experience also brought me into contact with many colleagues practicing in the region, that is to say, domestic Bosnian Council of all ethnicities, as well as the OKO, or in English, Criminal Defense Section of the court. My client in that case, Dusan Fushtar, who identified as a Bosnian Serb, was someone whom I had personally assisted to voluntarily surrender directly into the custody of the ICTY. We had spent several years in pretrial, and indeed were ready to begin trial at The Hague, when all of a sudden the Rule 11 procedure was implemented and applied to him, and he, along with 3 other co-accused, were declared ready to be deferred back to the State Court of Bosnia and Herzegovina. Now, as one of the first cases to be sent to Sarajevo, there were some hiccups in the process, as can be expected, which later on were rectified. One of the hiccups was in relation to the concerns over the security of the transfer of the detainees from The Hague to the region. And the transfer was so efficient and secretly undertaken that, in essence, even assigned counsel did not know when the transfer was going to take place. And we were not advised of the transfer, but then we were also not advised of the first court appearance either, where we were expected to appear. So that caused a bit of a problem. And at this point in my story, enters a phone call I received one morning in my office in Chicago from Sarajevo, from a gentleman who identified himself as Rupert Skilbeck, who introduced himself as the director of the Criminal Defense Section, OKO, of the State Court of BIH. And he was asking me if I was aware that there was a court hearing tomorrow morning in Sarajevo and if I was planning on attending. Now, I was rather surprised, as you can imagine, and rather worried because I sat there already doing the math in my head, knowing that I could not get on a flight in time to get out there. 2, I was not yet licensed in Bosnia and Herzegovina, and so I probably can't just show up and knock on the door and say, hey, I'm here. And before I started to panic too much, the whole endeavor was made much easier by that organization, the OKO, and by the efforts of that gentleman, who advised that he could appear as duty counsel on behalf of all 4 of the accused, if myself and the other attorneys sent written authorizations, which I then organized with my colleagues. And he obtained a continuance of the hearing, and thereafter sent us all the necessary paperwork and helped us fill out the paperwork and submit the paperwork to be admitted to the local bar in the State Court of Bosnia and Herzegovina. And within a matter of, I think it was days or weeks, I was admitted to the State Court of Bosnia and Herzegovina. And frankly, without that assistance, the situation of the 4 accused showing up without their attorneys, and definitely the 8 defense counsel, would have been quite a headache and a hassle, and perhaps even a train wreck. That happens sometimes. But with the assistance of OKO, not only myself, but also one of my other colleagues from the case, who was ICTY counsel, remained in the case and became accredited at the State Court of Bosnia and Herzegovina. And I, therefore, acted in that capacity through trial, and ultimately our defense was able to enter into one of the first ever plea bargain agreements for that court for war crimes cases, which introduced that mechanism to the local judiciary. Okay. This was due in part to 2 prosecutors in that case who were from America and Australia respectively, and developed a good working relationship with the defense. Now, coming from the ICTY and common law background, both helped and hindered me at the State Court of BIH. It assisted me in that I and the other ICTY defense counsel had access to the documentation that we've been disclosed by the prosecution in The Hague, and we could read it because, of course, we were both English speaking, and some of the documentation was only in English because statements, if they were not being used as evidence, would be signed in English irrespective of the language of the declarant. And many local counsel had a hard time locating documents, et cetera. But even with my bilingual background, some things were difficult and different. There was no written transcript, so all we received were audio recordings of the hearings. And so it's hard to kind of make a reference to say, well, you remember yesterday when you testified, I think it's somewhere 2/3 of the way in on the tape, you said X, Y, Z, and the witness could say, no, I didn't, and you had a hard time confronting him with that. But, we learned to do that. Now, another problem was motion practice in dealing with various criminal codes and laws that we were not familiar with or that were evolving at the time. And the rules had changed so much that one of my co-counsel, who was a former military prosecutor born and raised in Sarajevo, appeared, and courtroom number 4, I believe it was, in the State Court of BIH, was his former office. So he was quite familiar with the building and the environs, but he, just like myself, was confused with some of the new jurisprudence and laws. And this OKO assisted us in that, and because we had such a positive experience with OKO, we defense lawyers who had previously worked at the ICTY were very open to working with OKO because of our very good experiences with OLAD at the ICTY. And so for us, it was a very logical transition, whereas most of the domestic attorneys were kind of skeptical of OKO, and they kind of looked at OKO as, hey, are you really going to keep secrets, or are you going to tell our secrets to the other people in the building? And so they were very reluctant to cooperate with OKO. And I think after seeing OKO assisting us, I mean, they would follow other cases and therefore let you know if an issue that was relevant in your case was being litigated in another case, provide you the research materials, provide you with public filings, which was very key because there was not an electronic database that you could use to make such a search and get that information yourself as a defense counsel. And eventually, the other attorneys started to work with OKO after seeing us do that, I guess. And looking back now, some decade or so later, OKO is no longer viewed with skepticism by local counsel in the State Court of BIH. And in fact, OKO now regularly holds trainings, and I was actually invited back in 2011 for one of their anniversaries and trainings, and welcomed by all the staff, who again are of different ethnicities, but to them it did not matter the ethnicity nor the crimes for whom the accused were alleged to have committed. Their job was to professionally provide assistance to the defense, and they did so very well. And looking back 10 years later, OKO now has a very positive reputation, and at this anniversary there were many defense counsel present, and I think that is a tribute to the positive role of OKO at the state court, which I think mirrors the positive role that OLAD, the Office of Legal Aid and Defense Matters, has had at the ICTY. Now, 2 minutes, okay. 2 minutes, I see. Okay, so I'll talk about one aspect that was a little bit interesting, the use of ICTY statements in the State Court of BIH. I remember one witness where I'd started reading from his ICTY statement, and the answer to everything that I read from his statement was, that's a lie, that's a product of the Serbian propaganda system. And since it was his statement, I said, well, sir, neither in this statement nor today have you identified during what period of time you worked for the Serbian propaganda service. Could you please tell us what the time period that was? And he kind of didn't know how to answer that. And the judge, realizing what was going on, really cut things short and said, let's be clear. Are you disavowing your previously sworn statement made under oath? And the person said, no, if it says that in there, it's true. And then continued answering everything that I read from the statement honestly, thereby contradicting much of what they had said during the prosecution's case in chief, which was direct examination, excuse me, which was very good. And in that sense, my experience in Sarajevo had an immediate impact on my ICTY experience, because the case I was working on concurrently, Milutinovic et al., the prosecution had wanted a large number of ICTY written statements to come in without cross-examination. And we, the defense, objected, and the trial chamber agreed with us and required the witnesses to come. And here, I always like to quote the Honorable Lord Ian Bonamy, who was the presiding judge of that case. This can be found in public transcript, page 2675 and 2677, when the prosecution was complaining about how, they hadn't met with many of these witnesses because they thought the statements would just come in, without any kind of cross-examination. And Judge Bonamy says, and this is now Judge Bonamy, you'll have to imagine a Scottish accent. I can't do a Scottish accent. But he said, well, I can say that the first reason strikes me as extraordinarily naive because one thing that's absolutely clear from the way in which this case has been conducted so far is that there could have been the grossest miscarriage of justice if these witnesses had not been available for cross-examination. He went on to say, well, all that's happened, though, one thing that's become clear through cross-examination is that it is necessary. I shudder to think what might well have happened without that opportunity being available. And I think that highlights the importance of the defense role in both the ICTY and the domestic courts in the region, and I'm getting the sign that my time is up. Is that correct? I thank you for your attention, and I pass the baton on to the next speaker.
Thank you, Danny, and thank you for the references. That's excellent. Well prepared, counsel. We'll move on now to Mr. Christopher Gosnell to share his experience.
Well, since the title of this panel discussion is Experiences from the Front Lines Defending Justice, I thought I would, to adopt the metaphor, discuss three theaters of operations of defense counsel that are important. One is dealing with clients. The second is about dealing with witnesses from the perspective of defense counsel out in the field. And the third is particular experiences in the courtroom. Of course, I'm not going to be able to tell you everything about that, but I will tell you one or two thoughts and anecdotes that I personally have experienced in those domains. But before I do, it's very important to understand the context in which defense counsel did operate or are operating in the context of the ICTY. And I now see that through the lens of subsequent experience that I've had at the ICC. And only now do I realize, in fact, how good we had it at the ICTY. And there are really two aspects that, for me, stand out as fundamental, but because they were so ubiquitous and so omnipresent for counsel operating at the ICTY that we just took it completely for granted. And if you spend any time at the ICC, you will no longer take it for granted. The first is that when you're out in the field and dealing with any type of investigations, trying to follow up on any instructions from a client, trying to essentially do anything at all, the fact that you were doing that in a place like Serbia, Croatia, or Bosnia, which are relatively developed, relatively stable environments and societies at this point, affects fundamentally and pervasively the kind of interactions that you're going to have with individuals who you may want to call as witnesses, or you may decide you don't want to call as witnesses. But the point is, the fact that those societies are relatively stable means that you actually can have discussions that go beyond reactions based on identity or based on an expectation of benefit. And I'm talking quite simply about money. Because a lot of witnesses or potential witnesses whom you come in contact with in very poor societies, that is an overriding consideration in terms of the nature of your interaction with them. And that can make a job of an investigator or a counsel extremely difficult, trying to separate the wheat from the chaff. And there's no comparison whatsoever between Bosnia, Serbia, and Croatia and the kind of environments that the ICC is dealing with. The second, but by the way, it wasn't always like that. By the time I got to the ICTY in 2008, it was generally like that. But I heard stories from friends of mine who were at the ICTY many years earlier, who had been in Belgrade, living in Belgrade, working on defense teams while NATO was bombing Belgrade. Just imagine the bizarreness of that Belgrade is being bombed by NATO forces. All of the countries that are the sponsors of the ICTY, and all of those countries are bombing the city that you live in, and your office where you have all your files in an ICTY case, that's being bombed. And then you're expected to come back to The Hague quietly and sort of stand up in court and say, you know, well, Your Honor, I had some trouble seeing a witness this weekend because, you know, the bridge to some place was destroyed by NATO bombing. So it wasn't always like that, and it is important to remember that there is this strange oscillation between the bizarre and the normal in international criminal justice. There are times when international criminal justice is more about being an instrument of foreign policy. And in 1995, when about 2 weeks after the Srebrenica events happened, there were 2 indictments issued about those events. That's when international criminal justice was an instrument of foreign policy. And there's nothing wrong with that. There's nothing wrong with saying we are going to denounce this as presumptively a mass criminal event that is going to be pursued when we can. But no one could have been fooled about the fact that it would have been possible to go out and conduct an investigation on July 28th, 1995. Entirely impossible. No one would think that. And if you had tried to say we're going to do that, then any lawyer who would have been involved would have understood right away there's absolutely no chance that this actually is going to resemble any criminal justice process that anyone has ever been involved in their own countries. So there is this oscillation between the bizarre and the normal. Instrument of foreign policy on the one hand, and then eventually when a situation becomes more stable, then there are the conditions ripe for having a proper criminal process. And this actually leads me to the second contextual factor, so important at the ICTY, so important to the experience and the satisfaction that lawyers can or cannot have, depending on what system they're in, is the degree of repetition, of reiteration, the numerosity of cases at the ICTY. There were so many cases at the ICTY, there were so many trials ongoing simultaneously that it created a bar. There was a defense bar that came to exist. By 2008, when I got there were plenty of defense lawyers who were just as experienced as prosecution lawyers, who were just as capable of going into the courtroom, citing the jurisprudence competently, cross-examining competently, presenting their cases competently. Very early in the histories of the tribunals, I think it's fair to say that there was a bit more of an advantage on the prosecution side. But gradually the defense bar coalesced, shared experiences, developed expertise, became involved in case after case, and understood how to respond effectively to the cases that were being presented. And also the fact that there were many cases meant that what was going on in the courtroom became more predictable. And that's really the essence of the rule of law. It's the essence of legal practice. Going into court, having some sense about what's going to happen, trying to figure out your strategy, and stand up on behalf of your client and present their case as effectively as you possibly can. If there is only one case every 3 or 4 years, it increases tremendously the unpredictability, reduces any sense of developing a strategy as to how you should carry out your case, how arguments should be presented, and what might happen at the end. And that also undermines the possibility, for example, of plea agreements, because nobody knows, based upon the facts and the evidence that's being put on the table before a trial starts, whether or not that is a good or a bad idea. So these are two aspects of my own experience at the ICTY when I look back on it. And by the time the Hadzic case came around, which was the second last case, I remember thinking to myself, my goodness, it's so easy walking into court and knowing what is going to happen on any given day, knowing how any particular procedural matter is going to be dealt with. And what happened was, of course, is that the lawyers knew that, and none of those issues came up. Whereas many of these issues at the ICC are litigated to the extent that it distracts attention from the core issues, which is trying to figure out what exactly the evidence shows. And this is, for me, a tremendous difference between the ICC and the ICTY. It's that the ICTY, despite the cataclysmic events that were the source of the cases, despite the bizarreness of the fact that at the beginning these were indictments that never could have been the object of criminal justice, they became normal. The cases became somewhat normal. The practice felt like a regular criminal proceeding in a domestic jurisdiction. And I have to say also that to some extent that had to do with the professionalism of the prosecution. Because personally, I feel that generally the prosecutors were professional, and it made it more pleasurable to be in court as a defense counsel presenting a case when that's the case. And it's easier for them to be professional when they have that particular situation as a backdrop as well. So 3 front lines. First front line, which for me was a total shock when I went from the office of the prosecutor to working for the defense, was when the first time I went and saw my client, and I suddenly thought, are you just going to allow me into this room and talk directly to the client so that I can know everything that happened? And I'm going to have a bunch of people who are from the region who are also going to immediately give me access to people who will tell me what happened and who aren't going to put up a lot of resistance and say, no, I'm very guarded, I'm not going to talk to you. In the office of the prosecutor, there were some local investigators, of course, but first of all, many witnesses are very guarded in respect of their contacts with the office of the prosecutor. And secondly, there are less local people who are working in the office of the prosecutor. And one of the aspects of a defense experience is you are immediately in the middle of local knowledge, local staff, and people who actually really know what happened. So you actually know a lot more about what happened, and then you have to be actually more restrained and careful about how you are presenting everything that happened. Whereas on the prosecution side, it tends to be more, give me everything I can possibly get, and I'm just going to dump it in front of the chamber because there's enough incriminating elements that probably I can get this case over the line and get the accused convicted. It's a fundamentally different type of experience. And balanced with that is the fact that you as the defense counsel, sometimes Western, sometimes local, or sometimes somewhere in between, you are where the rubber hits the road between the region and international justice. It's you who has to communicate what's going on, which, by the way, is one of the fundamental aspects of any criminal justice system, making sure that the accused is a participant and not merely an object. And that is one of the fundamental roles of a defense counsel. At the same time, you're involved in a very long case. You get closer to your client than you would in most criminal cases. And by the way, that's both vitally important, because it's very important to explain often to an accused what is the best strategy. And sometimes the accused is not necessarily trusting of the advice coming from someone whom they've never met before, who is, for example, a Westerner, or very different from, not from their culture. And so you need to develop that rapport and that relationship. On the other hand, developing that relationship can implicate you more than you might want to be implicated. Your own judgment can be affected by that. You can sometimes make the wrong decisions because you are too closely or identifying too closely with your client. It's an extremely hard balance to strike, but one that defense counsel have to find. I have limited time, so I'm actually just going to skip to the third front line, which is the courtroom. And it's possible to reduce the types of witnesses you see in the courtroom to basically 3 categories. There are international witnesses who are generally perceived as credible, but oftentimes actually quite ignorant of really what went on. There are local witnesses who were not directly involved, who have a pretty good idea of what went on, but especially if they're victims, then they're obviously very biased and have a very particular perspective that they are only too willing to give to you, and with maybe some additional details and embellishments. And then the third category of witnesses are insiders. And if you are a defense counsel and you're meeting an insider, the problem with them, even though they're highly knowledgeable, is they're also highly motivated to lie. So you have these 3 types of witnesses: ignorant, credible but generally ignorant. Then you have victims, knowledgeable but also extremely motivated to testify in a particular way. and then insider witnesses who are only too happy again to take the part of the accused. Judges know this. Judges perceive this, and judges have to make their own assessments as to who they're going to believe and what they're going to consider credible. And I must say that this is one of the hardest challenges of being a defense counsel, because what you're dealing with often is witnesses in the latter two categories who are not speaking the languages of the judges, and who are saying things and whose credibility is going to be judged according to descriptions that involve presumptions, cultural presumptions often, that if you're from the culture, you will immediately identify this is true, this is not true, this is plausible, this is not plausible, the person is being evasive, they're not being evasive. I had an example recently in a case where one witness came and said, in respect of a Rwandese person, if they don't look you in the eye, I consider that the person was telling a lie because they weren't looking me in the eye. 2 witnesses later, another Westerner, and the first witness was a Westerner, the second witness, who was also a Westerner, came and said, well, I spent a lot of time in Rwanda, and if someone was, and the Rwandan in the Rwandan culture, you do not look somebody in the eye right away. I would actually consider that to be an indication that they're lying, that they're trying to deceive you, because it is actually not normal. This is the kind of background assumption that makes the work that goes on and the assessments that go on in the courtroom so difficult, and what makes it so hard for a defense counsel who knows a lot, has heard a lot from their clients, has a much better mastery of actually what really went on, but may have a lot of difficulties making decisions about what information is necessary to bring out and to highlight these kind of subterranean elements, if I could put it like that, for the judges in their assessment. And the problem is, especially at the ICC, is that there are so few cases that it's hard to know how to make those judgments. And at the ICTY, as hard as it was, at least we had enough cases where we could make a pretty good guess. That's it, Marie.
It's beautifully timed. Thank you, Chris. We'll now move on to our final speaker in this panel, Mr. Gregor Guy-Smith.
I am an insomniac. As long as I've practiced criminal defense, I've been an insomniac. I worry every day, as my colleagues worry every day, as to whether or not we have done enough. Whether we have prepared enough, whether we know the facts well enough, whether we understand the law well enough, whether we understand the culture that we're involved in well enough. One of the things that is, and because we were talking about the legacy, that is actually true about the ICTY, and I say this having spent the last 3 years trying cases in the ULEX courts in Kosovo, is it at the ICTY it became, in fact, the flagship for the practice of international criminal law, because ultimately there was an openness and a desire to learn from each other, to respect each other, and to the extent that the defense function is ever respected, it was respected and has been respected, ultimately the ICTY with greater success than anywhere else. and that includes, as far as I can tell, what is presently occurring at the ICC. And the reason that I say that is my understanding is that each and every case that is presently active at the ICC, there are either Article 70 investigations or Article 70 prosecutions, which involve, in each and every case, the defense and the defense function. Clearly, if we have courtrooms where the defense function is not respected, and the defense counsel and their teams are not respected to be honest, hardworking, with integrity, and full of piss and vinegar to fight for their clients, but rather considered to be individuals who are subject to investigation for inappropriate or even criminal behavior, there's no respect for the defense function. At the ULEX courts, and I'm raising this for a moment because I think it's important to understand some of the truly marked differences that exist. Although the law in Kosovo makes it quite clear that the accused is entitled to a verbatim transcript of the proceedings, no such verbatim transcript of any trial that I have been involved in exists. Minutes exist, but not verbatim transcript. And the importance of that will be if in the future any of those minutes are used in future proceedings anywhere in the world, what is the reliability of that information? What is the accuracy of those proceedings? I was listening to a variety of different things that were said here today. And one of the things, again, that I think happened at the ICTY, reluctantly and with a great deal of struggle, was ultimately a balance was created between the rights of the accused and the protection of witnesses. The chambers that I was involved with, in the trials that I was involved with, recognized that there was a factual determination that had to be made in each and every case with each and every witness concerning the advisability of that witness being protected, the extent of the protection they would receive, whether or not the hearings would be held in open or closed session, and the effect that that protection would have on the credibility and the reliability of the trials. I've been involved in proceedings in other jurisdictions where witnesses who ask for protection are given protection without any consideration as to whether there's a factual basis for that request, without any consideration of whether or not there are lesser types, less intrusive methods that can be used for purposes of having a balance between the rights of the accused and the protection of a witness. And ultimately, a lesser consideration attitudinally for what it means to be tried as an accused in an international case. Because, let's be honest, the defense, not liked. The people who the defense represents, not cared for. Usually considered to be, one person I think here said monsters. Well, if I got monsters for the people that I've represented as the only criticism, I'd be a happy man. I'd be feeling pretty good. Now, the monsters that I have represented have been acquitted. Each and every time. One of those monsters had to be acquitted at trial twice. So the attitude of what happens in a courtroom and the attitude of how the defense is to be treated becomes relatively important in my mind. And I think in the minds of many of my colleagues on the defense. If you allow us to defend these people properly, if you give us the resources that we need, if you believe that when we stand and make the arguments that we make, both legally as well as factually, that these are arguments that are being made by officers of the court who believe and trust in a judicial process, then we will be satisfied. When Chris was speaking earlier, and he mentioned that there was a bar that was created, one of the things that happened right around the years that he was mentioning was that all of a sudden the trials that were being held at the ICTY were not all resulting in convictions. And there were all of a sudden a lot of complaints. Why aren't we getting convictions? Said one side. And the answer was, because the cases are being tried properly. That's why. Why were the cases being tried properly? Because, among other things, and quite importantly, there was a recognition by the chamber. There was also a recognition by our colleagues on the other side of the aisle that the defense function is an important and critical function in the delivery of justice. And that if you honor that function, if you give credit and credence to the defense, you will end up with, we will end up with, society will end up with a system and results that allow for better resolution of very, very difficult questions in the criminal context. There's an old, saying which is that a trial is the crucible of truth. Now, one would argue that much of what happens during a trial is open to question as to how true it is or how true it's not. But what is certainly is accurate is a trial is a crucible. And in a trial, the kinds of questions and the kinds of issues that Chris alluded to with regard to witnesses come up on a daily basis. And in that context, once again, in the two sides of the story of a trial, where there is a recognition of and respect for the defense, you're going to get good trials. You're going to get fair trials, which is one of the things that I think ultimately is a success story for the ICTY. I'm not sure it's going to be a success story for the ICC. I hope so, but I'm not sure about that. And with regard to the institutions that are coming in the future, I hope that they will be cognizant of and careful of respecting the rights of the defense. And the rights of the defense mean making sure that there are resources available, that the information that the prosecution has is given to counsel and to counsel's team so that they can seriously and adequately prepare and see that information, review that information, investigate that information, challenge that information. That the time that is necessary for adequate preparation is given to defense counsel, that they are not hurried or pushed because of the need or the desire to have things resolved quickly. Because although there are foreign policy considerations in international criminal trials, the trials are about the guilt or innocence of the accused. They're not about foreign policy. They should not be about foreign policy. They should not be about regime change. That's not what a criminal case is about, and that's not what an international criminal trial is about. I want to end with a very brief thought, which is what criminal defense attorneys do and what international criminal defense attorneys strive to do all the time is shoot out the lights. And what that means is act superbly, do the best they can for their clients. And shooting out the lights comes from that old stage theater where there would be a candle flickering, and the idea was to extinguish the candle without touching the wax. Pay attention to detail with an unerring eye and the greatest commitment. Thank you.
Thank you, Gregor. We are only a couple minutes over, which isn't too bad. I understand we do have to be out of here at 7 o'clock, though, very sharp. But that gives us 30 minutes for any questions that you may have in the audience. I see there are a lot of people who did, as I said, work on defense teams too, so if you have some contribution as well, short comments are also allowed, just respecting the time of everyone else who may have a question or comment. I'm not sure where the microphones are, but if you put your hands up for anyone who have. And if you can introduce yourself for anyone who might not know who you are. Mr.
This
Jay.
works? Okay. Hi, I'm Dov Jacobs. I'm a professor here, assistant professor here in Leiden University. I'm also on the defense team of Laurent Gbagbo at the ICC. I won't comment on the ICC part because maybe given how it's going, we might have a legacy conference as ICC in a few years because it won't be working any longer. So I'll reserve my comments for that moment. 2 points. One, in your experience, you spoke, Mary, you quoted the judges at the beginning, and I was wondering if you can reflect on the importance of the judges in ensuring fair trial, because one of the issues at the ICC is the lack of experience of judges of the criminal process, of an international criminal trial, and you might have the best texts ever, you might have an ASP or drafters who understand the problem. If you have judges who are practiced in civil law, who don't know what a trial is, you know, how much a defense needs, what it means to look through thousands of documents, then you won't get anywhere because that's a problem. So I know how it is at the ICC, and this is a problem. So I was wondering if you saw an evolution at the ICTY, which would play into the success story you mentioned, Gregor. The second point is more philosophical, if I may be a bit of a devil's advocate here, is you mentioned that the people you defend, that we defend, are considered as monsters, and I always wondered, and we discussed this with Colleen often, is fairness really possible in an international trial, in the sense we understand it from a domestic system or an idealized, fair trial system, because of the context. And Gregor, you said it's not geopolitical, but the fact is that international trials do exist in this context. Prosecuting a head of state who's still in power, de facto is a regime change. There is a context which changes the nature of an international criminal trial, and to do a bit more promotion for Colleen's book, I wrote in that book that given that specific nature, it is impossible to understand an international criminal trial as a criminal trial, that we've been mistaken on the language we use, that the context, that the presumption of guilt, all this makes it, the role of victims, all this makes it impossible to be fair. Which leads to my next question, final, it's just a question. At some point, if the system cannot be fair, to what extent, as criminal defenders, lawyers in that system, are we not complicit with the system? How far is it that we are inside trying to make it better, which I accept, but at what point do we just shut the door, slam the door, saying it's just unfair? By being in it, even trying to change it marginally, I'm actually giving it legitimacy as a defense lawyer. They can pretend that we're fair because all the defense lawyers are there, look at them, talk. But in fact, we're giving legitimacy to a system which is fundamentally unfair, and we're complicit with that. Thank you.
Thank you, Dov. Before we answer, is there another question? I see in the back there's a hand. Maybe we can group them, work out who wants to answer.
Thank you. Thank you. My name is Anderson Duracea. I'm from the Dominican Republic. I'm doing the Advanced Master in Public International Law here in Leiden University. Well, my question has 2 points, and it is basically about the Association of Defense Counsel. How do they involve in the election of judges before the international courts and tribunals? And my question is because how regular it is to turn between a defense counsel to a judge in an international court, because as I have recalled from your speeches, there is a different view and perspective of justice and fair trial from a prosecutor perspective and a defense counsel. So how do they involve as judges, and how judges guarantee fair trials if they have this background of defense counsels? Thank you.
Was there one more? We can take these in threes if that's, even though that one counts as two. There's one down in the front here.
Thank you. My name is Erik Kok. I've worked at the ICTY for a little bit. My question is this. As you've all noticed, there's lots of information that needs to be interpreted, a witness, documentary evidence. I've often wondered, the more information you get, the more information you have to interpret. Do you in the end up with, basically ascertaining the truth? Or is it not better to say, okay, it is a folly to just try and, rethink, find out the whole history? Should we not focus on essentially a few witnesses, a few acts that we can actually, be sure about? Because is it not in the very essence of these huge trials that you just have a load of margin for error? Thank you.
Thanks. So the first question, I think, was addressed, the first part of the first question was addressed to,
If I understand understood the first part of your question, I believe that the clearest answer, and I am paraphrasing slightly, Sharif Bassioni, who said that it was inexcusable for any court to have within its chambers judges who were not qualified, who had not been practicing judges, who did not understand what it meant to conduct a trial, who had not been versed in the law, who had not, in fact, perhaps themselves been practitioners either as lawyers or clearly as judges. For the most part, in my experience, the judges that I appeared before there were real judges. I can argue about whether I like some of the rulings, can argue about whether I cared for some of their philosophies. We can argue about whether or not the rapidity with which some judges achieved their conviction team in a long trial was appropriate, but they were all judges. They knew how to practice. They knew what they were doing. I don't think these cases can be tried by, or should be tried. Well, they can be tried, but I personally don't believe that they should be tried by anybody who does not have qualifications as a judge. I think it's irresponsible to the legal community, it's irresponsible to the international community, and it's irresponsible to the history of the law. That's my opinion.
the second part of the question was about if they're monsters. It was two parts. If they're perceived as monsters, can they necessarily receive a fair trial? And if no, is there a joint criminal enterprise of the defense counsel in this process with the other actors of the court? Does somebody?
I'll answer part of that question very quickly. Since I use the term monsters, the answer is yes, they can receive a fair trial. I've represented monsters who have received a fair trial at the ICTY. And using those particular terms, and my clients were considered to be monsters. With one of them, the acts were considered to be reprehensible. They were accused of doing a series of things they never did. The judges were able to sift through the facts, sift through the legal arguments, and I think came up with very fair results. They were acquittals, so obviously I think they were extremely fair results. With regard to the second part of your question, which is, aren't we assisting. I am concerned that we may well be, as a general proposition, assisting because there's not as much clarity with regard to what the actual struggle is in terms of criminal cases as there should be. And I'm stopping there so other people can respond.
I had just a couple things about the last point, but one thing to say that's perhaps slightly off topic, but it's a big issue for me. Going to the ICTY, I would read indictments, and I'm thinking in particular of the Hardini case, which Grigori and I did together, and our client was a guy named Idris Balai. He was the commander of a special rapid intervention unit during the war. And if you read the indictment that the prosecutor wrote, word for word, Idris Balai was at every crime scene that ever occurred throughout Kosovo during the war, and the most atrocious crimes that ever occurred, some of which I will not describe in public because of the absolute brutality and horror of them, were all committed by Idris Balai. And I think one of the things defense lawyers have to do in the courts, and in this sense, we're not complicit in the process, we're there to assist, is when you get a case like that, you stand up for that client and you look through that evidence. And in the particular case, none of the allegations were proven, literally none. So it was very, very important that their defense counsel there and teams, there were 3 teams in that case, who were willing to say, no, I'm not going to believe this just because it's in an indictment and it's running around in the press in the region and everyone says it's true and this guy is the devil himself and boy, are we glad we arrested him and he's a monster. No, he wasn't a monster. Wasn't a monster. Family man, caught in a war, 23 years old or something when this was going on. So although I understand the argument that one can be complicit in a system because you're, of course, participating in it, part of me says, well, if we leave, then what happens? There may need to be another way to address a system like the current international criminal law system, which, in my opinion, is veering sideways off the highway. I agree, the ICTY had excellent jurisprudence and developed as time went on. The ICC, I think, is dramatically going in the wrong direction, as I understand it. Chris has had cases there. I have not had to do a case there, only witnesses, so I have a limited commentary there. The other thing is about the judges. Sharif Bassioni made a comment about the judges, and I like to quote it a lot, although at this moment, of course, naturally, I'm not remembering exactly what he said. But basically what he said was, a court is a court. It can't look like a huge UN organization. The ICC is not an NGO. It's a court. And the people who are there need to be qualified to function in their roles, and there are judges there who are not. And it's a reality that needs to be addressed that everyone in the international community seems to be too polite to raise. But it's the truth. Do you want to have those people returning decisions in these important international cases? Is that okay with you? Because if it is, then we are complicit. It's not okay. It's not okay that most of the proceedings there are held behind closed doors. It's not okay that witnesses are paid. It's not okay that cases are dumped en masse because no one bothered to put them together correctly on the prosecution side. And I don't want to be critical of the prosecution, particularly here, because I don't work in that office. I don't know what the restraints are there. But I think we need to take a very cold, hard look at where international criminal law is going right now. Chris, maybe you want to, or make a comment?
Well, thanks, Dov, for your very non-provocative comment about the complicity. I do think about it. I do think about it a lot, but I'll approach it from my own subjective experience, which is I think about it a lot when I'm walking around in the corridors and when I'm reading things that have been written and that I'm sent and reading submissions, and I feel it less when I'm in the courtroom. Because at the end of the day, when you're in the courtroom, you've got the star witness of the prosecution in front of you. That's the opportunity to show whether or not the emperor has no clothes. And oftentimes, and I'm sure you've experienced this and others have experienced this, you look at a witness and you look at a charge and you think, boy, it's over. I mean, this is terrible. He's clearly guilty. This is such a strong witness. It's so definitive. And then you just start, peeling away the onion layers, and all of a sudden, it's not quite what it appeared to be before it was tested. And I'm speaking subjectively, once you get in the courtroom, or at least when I get in the courtroom, I must say that personally, that's when I feel most relaxed and comfortable and useful in my role as a defense lawyer. And so I do take comfort in that. The major caveat to that, and it's a big problem, is the extent to which ICC proceedings are in closed session. Because even the prosecution concedes and admits and has said in written filings that closed session encourages witnesses not to tell the truth, because they know that no one's listening, and when no one's listening to prosecution witnesses and their testimony, when the defense goes out and does its investigations, there's zero chance whatsoever of somebody saying, I heard over the radio that there was this testimony about your client running off to this location and killing 45 people. It won't even be known that there was that testimony, and there's zero chance that someone is ever going to tell you spontaneously that the testimony at the trial was false. Something that we take completely for granted in a domestic setting, and it is profoundly undermining of the fairness of trials, which is itself essential to good trials, which itself is essential to the legitimacy of outcomes, which itself is essential to the whole point of all this, which is to give communities a chance to look at these proceedings as a model and as a way of healing and getting to the truth.
I want to take that one step further, or not necessarily further, which is if when you're out there as the defense counsel investigating a case, and then you come back to the court and you're informed that you're involved, you now are you're now involved in an investigation of yourself because you've been out there investigating a case, and there's something wrong with that. That doesn't help a great deal. And anonymous witnesses are bad witnesses for the system of justice. Period. No ifs, no ands, no buts. That's a bad witness.
I think we're going to move on
There
to
was a
the.
question there.
There was a question.
Well, there's.
And there was a question there.
There was a question. There was a question at the back about the prosecution and defense, and it was an interesting question.
We were stuck on part 1 and 2.
There
We'll
was a
move on to the
second question.
Yep, the second question, I believe it was, what is the ADC's role in the election of judges, partially? And also, how often have defense counsel become judges, and what impact does that have on a bench? And I think
That's a
Paulina
really
did-
simple question. The ADC has no role whatsoever in the election of judges. And the different courts are organized differently, but the judges are elected through a process that it's over and done with by the time the court is there. They're elected through their countries, a series of other things. I really don't know exactly how those elections function, but certainly the defense has nothing to do with it. I actually thought you asked an interesting question about, wouldn't it be true that someone who was a defense lawyer would have a different perspective on the trial process than someone who was a prosecutor, meaning as a judge, when they become a judge? I think that that's true, but it's not necessarily what you think, that a person who was a defense lawyer would be more pro-defense, let's say, as a judge, than someone who is not. Sometimes it's the opposite. Sometimes someone who's a defense lawyer suspects everyone on the defense side. I've seen this in the domestic context and international. So I'm not sure any lesson can be drawn from that, although I do think that it's important that there's a diversity of ideas on a bench, no matter where you are. And in the international world, when you asked the question, I was thinking about, at the ICTY, there are 3 judges I can think of who had defense experience, but primarily not defense. They had some. There might be more, and I have no idea at the ICC. I mean, ICC, there are people who are diplomats, have never tried a case before. So I don't know maybe people have
If there are no, yeah, if there are no other comments on that third one, then we'll go to Eric's question, which Denny has said he would discuss, which was relating to when you have an enormous record, the ability to actually tailor that trial when you have the whole history before you.
And do you end up with the truth, or should we focus on what we're sure about? I think it depends a lot on what the purpose is, whether it's truth-finding, reconciliation, justice, etc. And different courts take different approaches to that. Speaking from a historical perspective, I've often felt that the indictments that have been issued at the international level and even at the ICTY are so grand and include so many different charges that it becomes very difficult to find information about each and every single event. It's hard to find a witness to cover each and every single event. In a sense, it becomes harder to be sure that you're able to get enough information into that proceeding to know exactly what happened, how it happened, by whom it happened. And in that sense, the job becomes much harder, and personally, I think it would be easier for everyone involved if indictments were much more streamlined and focused on specific instances that were clearly defined. I mean, we've had indictments that say sometime within a 6-month period, 3 persons were killed in the vicinity of an area. Where do you go from there? It's very difficult to kind of narrow it down and to prepare a defense when the indictment makes such broad and vague allegations. But I think many indictments that at least I've seen and defended against have had allegations that are exactly that vague and broad. It just makes your job as a defense counsel harder to go out and find witnesses. And of course, we try to narrow that down at the preliminary motions phase by arguing defects in the form of the indictment, and sometimes that results in refining the indictment down to a more manageable level, and sometimes, I don't think it does. But it's hard in these cases because they're always so broad and big to, kind of, I guess, stick to those well-defined incidents that can be investigated fully so that you have all the information before the court.
Were there any other questions? Because so many. Where were you the first round? I saw a hand go here, 2, 3. So we can probably do 3 if we're quick, if they're shorter.
Thank you so much. My name is Kasaun. You mentioned there is improper conduct in as ICC by the prosecution side. I recently, recently the ICC actually also found members of the defense team in the Bemba case guilty of improper conduct, and to what extent the ADC is actually controlling this kind of behavior from the defense side, and was there a similar type of improper conduct as a ICTY? That's my question.
Thank you. And if you could just pass it down, then we can do one there, and then there was one over here, and I think the rest will have to be done over the reception, probably.
Hi, Chris Van Eyck. I'm a student of Public International Law at Leiden as well. And my question has to do also with the processing of a lot of information. I've gotten the opportunity to see a lot of people speak, both from the defense and prosecution side of the ICTY. I've noticed that they tend to be on a continuum of either bothered by their past experience or even, I would say, in some cases, haunted. It seems like there's a lot of baggage that comes with defending or prosecuting such events. Would you, in terms of the support you got at the ICTY, has there been any psychological or any professional help in processing just the sheer emotional weight of everything you're dealing with? Would you recommend that for courts in the future, or is that completely unnecessary in your opinion? Or I guess otherwise, how would you process something like that?
Thank you for that question. And we'll have the one question over here, and then we'll do some answers.
Thank you very much. Philip Kostinetsky, studying at Leiden University College, The Hague.
My question regards potential conduct prior to sort of indecent conduct by defense counsel. What anonymized anecdotes can you share, or what literature would you recommend for those interested in understanding the legitimacy of defense counsel through the sphere of ADC disciplinary committee advice or other mechanisms regarding incidents where defense counsel wanted to self-correct for potentially undermining their own judgments through their relationship with their clients? Thank you.
Okay. Yeah, Colleen will take the first question. She's volunteered. Okay, do you want to start with that then?
Oh, start with
Yeah,
the last question?
sorry, she's going to take the
Okay,
last
I love the term indecent conduct by the defense. I'm not sure I completely understand your question, but I gather you're asking where can you get information about this? The kinds of cases that have been brought? Is that the essence of your question?
You mentioned the ADC establishing a disciplinary committee, which
Right,
advice.
right.
And I was curious, are there ways, that seems like it, I think that does increase the legitimacy of defense counsel in the eyes of sort of everyday people and in the legal sphere more broadly. And I'm curious whether you could offer anecdotes, one or two now, or just point to literature where people can learn about that process later.
Well, one thing I would say is that defense counsel is legitimate. So take my word for that. And when this international legal system grows up from its, I don't know, teenage years, or maybe we're in middle school now with the process, people will understand that it's important that defense counsel is there in order to have a fair trial. You don't need to read literature to know that defense counsel is legitimate and their role is mandatory. And, you know, I think Patricia Wald, who was a judge at the ICTY, said it beautifully. She said a well-informed defense is the sine qua non of a fair trial. And so the beginning point I've just made, the defense is legitimate. Secondarily from that, in the international world, most of the disciplinary issues that come up at the tribunals are conducted in confidence. So there's no place that you can go to get this information, although I'm a person who thinks that some of it should be made public, and if it's necessary and reasonable, you can take the name of the lawyer out if that's a way of maintaining everyone's personal dignity or whatever is at stake. But I can tell you that the cases in general involve maybe problems with people splitting fees that they shouldn't have, occasionally people revealing confidential information, that kind of thing. The better cases at the ICTY actually, in my opinion, involve what lawyers can say in public about their cases. And the rulings are things that I don't particularly agree with. One is that a lawyer who made a very bland statement in the Serbian press was gone after to be disciplined for engaging in conduct that brought the tribunal into disrepute. I think it was a real stretch. I think it was not a proper prosecution of this individual, and that defense lawyers can talk to the press if they want to, just like prosecutors do, and be careful about what they say. In another case, someone who made a statement in public to the press was not disciplined for it because the statement was an honest one, and the finding of the disciplinary panel was that this was someone who was expressing his opinion as he honestly held it. And defense lawyers get to have opinions too. So beyond that, I suppose there's literature involving the ethical standards that apply at the various courts. But if you want to have specific details, you're not going to find it because those cases are held in confidence. Does that answer your question? Yeah.
Ooh, we have 10 more minutes, everyone. It might take, just to get to the question in the middle, it's a very interesting question. If I can just quickly answer, I don't know of any support that has been provided at a level institutionally or even through an organization for the baggage, as you're saying, the baggage that gets carried around for the defense at the ICTY. It's something that has been, there's the support of the community of the ADC, but as far as any sort of actual programs, no. Though I do understand that other institutions going forward have put into place some measures to allow avenues for people to receive maybe assistance if for whatever it is that they've gone through in actually dealing with this type of cases, especially for long periods of time. I'm just going to, unless you'd like to.
Yeah, but I also think it's part of what,
Yep.
it's part of what you do as defense attorney. It's part of what we recognize is on our plate. You know, that's part of what you integrate. We probably, as a group, are pretty open and pretty forgiving, because the human condition is pretty frail when you get right down to it. It's very, very frail. It's part of what we accept, I think. I mean, I don't mean to be being presumptuous here, but I think that, I mean, that's something I've heard from almost every defense counsel I've ever talked to over the years, which is you understand that human beings make a lot of mistakes, and also a lot of mistakes are made about them.
I don't know if it's a mechanism for dealing with this baggage or getting help for it, but we do have an annual gathering where we like to gather and commiserate with one another and exchange war stories, and it's the ADC Legacy Conference, an annual conference. And this year it's being held on December the 9th. And so we kind of get together, we talk about various topics, and really those of us that have gone through these cases oftentimes do have a hard time explaining to people, especially lawyers who practice in other jurisdictions, how these cases operate and what specifically arises in these cases and how we do the role that we do. I think our role is essential, and this goes back again to the first question of our defense counsel complicit in a system. The way I see it, defense counsel are there and have to be there to defend vigorously the client sitting behind them and the entire society as a whole, not only that client. So the absence of defense counsel in that equation, I think that would be the error, not the presence of defense counsel. Okay, thank you.
And then back to the first question, since we went in a reverse order here, I think this side of the table was going to pick that one up.
Yeah, I can't talk about the details of the Bemba et al. Case because the case is still sub judice, and I'm counsel for one of the accused in that case. So I won't talk in detail about it. But there's something that all of you should understand about the structure of the defense, and that is that the only person to whom you're accountable as a defense lawyer for an accused is your client. You're not accountable to the registrar for your conduct of the defense. You're not accountable to the prosecutor. You're not accountable to the judges beyond the fact that you have to act as an officer of the court. But on a daily basis, in terms of how your work is supervised, it's not supervised. It's you're accountable to the client. And that may sound a bit shocking. How can it be that defense counsel are running around without any kind of supervision? Because it is a bit of the Wild West. And the lawyers are only as good as the clients know how to choose whether or not it's a good lawyer or a bad lawyer. Not all defense lawyers are good lawyers. Not all defense lawyers are incorruptible. And it's easier to have really bad lawyers for the defense than to have really bad lawyers for the prosecution. In the prosecution, there's a whole structure. There's hiring, there's vetting, there's supervision, there's all kinds of things. In the defense, there is not and there cannot be, because it is vital to the independence of the defense that we not be subject to those kind of controls. If we had those kind of controls, we wouldn't have the independence that's necessary to stand up to the onslaught of the charges that come from the institution. So to me, that's absolutely vital. But you raise the question of, well, how does the ADC get involved in this? And that's really the key question, because what we need as a bar is to develop structures that can I would say informally try to maintain some level of self-correction, but not through the kind of supervision or hierarchy that you would see in the other organs of the court. And that's an interesting thing because the ADC has nothing to do with the ICC at all. The ADC is only at the ICTY and the MICT and the ICTR? No. But it's a very strong, self-organized association of lawyers, which all of us are familiar with from our national systems, and the ICC doesn't have that. The ICC, and by the way, if you're practicing at the ICTY, you must be a member of the ADC. The ICC doesn't have that. You can practice at the ICC and not be a member of the ICCBA, which is the equivalent of the ADC. The ICCBA is also relatively germinal at this stage. It's slowly growing, slowly starting to have a presence, but there isn't that same level of functionality at this stage. That's changing slowly.
No more comments. I was only granted 10. There's 4 left here. I'm not sure we could really get through so many more questions. Looking over at the time. This is over there. There is a reception that follows right after this. So if you do have questions, everyone is likely circulating and able to answer further questions about this work. Danny has already mentioned there is the ADC conference if you want to know more about some defense perspectives on core crimes being discussed this year on the 9th of December. There are flyers where you can get more information about the ADC up here, which I have been told to point out. And as I said, I'm sure that all the panelists here who have been very, very generous with their time and information will be able to help answer more questions out over through the reception, perhaps with a tasty beverage. Thank you very much for coming then, and thank you to the panel so much. Thank you to the ICC